Now, on to Ohio law. Believe it or not, Ohio had a medical marijuana law from 1995 until 1997. Revised Code Section 292511, which makes possession of controlled substances a crime, had a subsection which read, quote, "It is an affirmative defense to a charge of possessing marijuana under this section that the offender, pursuant to the prior written recommendation of a licensed physician, possessed the marijuana solely for medicinal purposes." Close quote. Governor Voinovich signed the bill that enacted this affirmative defense subsection. The bill was nearly 600 pages long. One theory is that the governor signed the bill unaware that this affirmative defense language was in it. In the very next General Assembly, at Governor Voinovich's request, Senator Blessing, a Cincinnati Republican, introduced Senate Bill 2, which removed the affirmative defense subsection from the statute. This bill became effective in June 1997, and the affirmative defense for those possessing medical marijuana in Ohio was gone. In 2015, Ohio voters rejected the Ohio Marijuana Legalization Initiative. This was better known as Responsible Ohio. This initiative would have amended the Ohio Constitution to legalize the limited sale and use of marijuana and create 10 facilities with exclusive rights to grow marijuana. This initiative was defeated 64 to 36% in the November 3rd, 2015 election. So after a couple of false starts, the 131st Ohio General Assembly, with Governor Kasich's signature, has now enacted Substitute House Bill 523, the Medical Marijuana Control Program. And that's marijuana with a J. This new law does several things. One, it creates Revised Code Chapter 3796. This is under Title 37, which governs health, safety, and morals. Currently, there is no Ohio Administrative Code Chapter 3796, but this could change. Two, it directs and empowers the Ohio Department of Commerce and the Pharmacy Board to adopt administrative rules to regulate the program. Three, it directs and empowers the Medical Board to certify physicians to recommend medical marijuana. As discussed earlier, recommend is an important word here. Four, it establishes the Medical Marijuana Advisory Committee to advise the Department of Commerce and the Pharmacy and Medical Boards on the rules and regulations that they will draft. The committee has 14 members who were appointed on October 6, 2016. You can see the member roster on the Ohio Medical Marijuana Control Program's website. At least 2 of the committee members have been criticized for being anti-marijuana advocates. 5. The law sets forth qualifying medical conditions for which a patient may obtain medical marijuana. Currently, these qualifying medical conditions are AIDS, Alzheimer's disease, ALS, cancer, chronic traumatic encephalopathy, Crohn's disease, epilepsy or another seizure disorder, fibromyalgia, glaucoma, hepatitis C, inflammatory bowel disease, multiple sclerosis, chronic and severe or intractable pain, Parkinson's disease, HIV positive status, post-traumatic stress disorder, sickle cell anemia, spinal cord disease or injury, Tourette's syndrome, traumatic brain injury, ulcerative colitis, and any other disease added by the medical board. 6. The law permits the following forms of medical marijuana: oils, tinctures, plant materials, edibles, patches, presumably this means transdermal patches, vaporizations, and any other form approved by the Pharmacy Board. Also, the smoking or combustion of medical marijuana is prohibited. Finally, any form or method that is considered attractive to children, as defined by the Pharmacy Board, is prohibited. 7. The law authorizes 6 types of participants: cultivators, processors, dispensers, testing laboratories, patients, and caregivers. The Department of Commerce will license cultivators, processors, and testers. The Pharmacy Board will license dispensers. Cultivators are scheduled to be licensed beginning in May 2017. The others are scheduled to be licensed in September 2017. There is a 15% minority benchmark for these licensees. Testers must be independent from cultivators, processors, and retailers. For the first year, only well-funded, well-equipped public universities in Ohio will be permitted to be testers. And 8, the law addresses a host of ancillary issues like tax, criminal history, employment, financial services, and zoning matters. Notice that the program is, at this point, a mere framework. The administrative regulations will implement the framework. I'm recording this in November 2016. At this point, there are no administrative regulations because the Advisory Committee, the Department of Commerce, and the Pharmacy and Medical Boards have not yet written the regulations. These regulations are not due until September 8, 2017. Between now and then, the action is going to be in the administrative rulemaking process. So I anticipate a sequel to this presentation where I will be able to tell you what those administrative regulations are.